Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. In the recent case of MWB Business Exchange Centres v Rock Advertising, the Court of Appeal considered the validity of a clause that prohibited an oral variation of a licence agreement. In this case, MWB rented out office space to Rock. Rock fell into arrears, but MWB orally agreed a new repayment schedule, and it is understood that Rock was compliant with this revised schedule. However, MWB then decided to give notice of termination due to late payment and claimed it was not bound by the oral variation, as the licence specifically stated that variations had to be in writing and signed by the parties. Reversing the High Court decision, the Court of Appeal stated that the oral variation was effective and that all terms in documents, including a variation clause, can be amended at a later date if the parties agree. This decision is consistent with the Globe Motors Inc v TRW case that we reported back in June. Now, we think that these are worrying decisions, whilst it is of course understood that where the parties jointly agree to change something, they should not be stopped from making that change, but believe that the parties should still be required to agree on changes in the way that was contemplated in the original contract. Is a party bound by the terms and conditions that they have not received? This is a question that was posed in the recent Barrier v Redhall Marine case. Redhall's purchase order referred to terms and conditions over leave, although the terms and conditions were not actually printed on the reverse. The High Court concluded that the terms and conditions were incorporated, commenting that Barrier was notified of the terms and could have asked for a copy of them at any time. As reported in previous months, the Safe Harbour scheme that allowed for transfer of personal data to US Safe Harbour registered companies was invalidated in late 2015. Since then, there has been frantic work to create a replacement scheme known as the EU-U.S. Privacy Shield. This has been a rocky ride, particularly because of concerns that US government authorities are able to access EU personal data. However, the good news is that these issues appear to have been resolved and the EU-U.S. Privacy Shield has now been approved by the European Commission. US organisations will be able to seek certification for the scheme from the 1st of August. There is, however, a nervousness that the new scheme will be open to another invalidation attack in the European Court of Justice. David Cameron was the big advocate for new rules to allow employers to have frank conversations with employees about their future employment without the fear of repercussions simply because of the conversation itself. This right was implemented into law in 2013 under Section 111A of the Employment Rights Act. We'll refer to it here as the Protected Conversations Statute. It has now been tested for the first time in court. In the case of Faithorn, Farrell, Timms v Bailey, there had been without prejudice settlement negotiations, although the same detail was subsequently included in open correspondence and even in each party's tribunal papers. At a later point, however, the employer argued that the correspondence was inadmissible due to the common law without prejudice principle and by virtue of the Protected Conversations Statute. On appeal, the EAT determined that although the employer by its conduct had waived its right to rely on the without prejudice rule, the Protected Conversations Statute offered broad protection and could be used to stop the content of the offers being revealed and even any information about there being an offer. It is worth noting that the Protected Conversations Statute only applies to unfair dismissal claims and not discrimination claims. Rules implemented under the Immigration Act 2016 to crack down on the hiring of illegal workers took effect on the 12th of July. The new rules mean that employers will be guilty of an offence if they employ an individual while having reasonable cause to believe that their immigration status disqualifies them from working. Previously, it had to be proven that the employer knowingly employed people who were not legally entitled to work in the country. Employers convicted of an offence could also face unlimited fines or be jailed up to 5 years, compared with 2 before. A recent decision by the Employment Appeal Tribunal found that the dismissal of an employee for putting comments on Facebook about a colleague was unfair. In this case, Mr. Daly had a disagreement with the manager and posted a derogatory comment about the manager on Facebook. Mr. Daly did offer a full apology but was later dismissed for gross misconduct. Ultimately, the EAT determined that there were flaws in the employer's policies and procedures that rendered Mr. Daly's dismissal unfair and awarded him €5,000. The employer's failure to consider other, more appropriate sanctions at any stage throughout the disciplinary procedure was a flaw that weighed heavily against the employer in the EAT's decision. Now, this decision underlines the importance of having clear employee social media policies. The recent case of Pickwell v Procam considered the enforceability of post-termination restrictive covenants. Whilst restrictive covenant cases always rest heavily on the specific facts, this case still offers some useful guidance. The claimants, Ms Nichols and Mr Pickwell, had worked as agronomists with Procam. They both signed contracts approximately 1 year before they were qualified that included a 6-month post-termination non-dealing and non-solicitation restriction. In 2015, they were both tempted away to join Procam's competitor, Frontier. The claimants argued that the post-termination restrictions were unenforceable, highlighting the recent similar Bartholomew's agri-food case, whereby restrictions signed when the employee was a trainee were found to be unenforceable. The High Court, however, distinguished that case. The Bartholomew's case had widely drafted non-compete provisions, whereas this case only had a non-dealing and non-solicitation clauses. The more narrowly drafted clauses, coupled with the fact that the claimants had been given access to commercially valuable work, valuable status and training, led the court to determine that restrictions were reasonable and enforceable. The Court of Appeal has confirmed in the case of Cartier International v British Sky Broadcasting that the High Court was right to extend the granting of blocking injunctions against internet service providers in relation to websites whose operators infringe trademarks. This has been an established practice in relation to copyright and is specifically provided for under the Copyright Designs and Patents Act of 1988. But until now, there has been uncertainty about whether the same would apply to trademark infringement. This is therefore good news for brand owners tackling intellectual property infringements. The Consumer Rights Act that was implemented on the 1st of October 2015 allowed for the possibility of opt-out class actions for private enforcement of competition claims. On the 21st of June this year, the United Kingdom Competition Appeal Tribunal published notice of an application to commence a class action. The action is brought by Dorothy Gibson and the National Pensioners Convention to act as the class representative in bringing opt-out collective proceedings against Pride Mobility Products Limited. This action is a follow-on claim for compensation following a 2014 Office of Fair Trading decision that found that Pride and other retailers entering into agreements aimed at prohibiting online advertising for certain models of Pride mobility scooters below Pride's recommended retail prices. If this action continues, it will be the first competition opt-out class action to be heard by the Competition Appeal Tribunal and will pave the way for similar actions in the future. The Competition and Markets Authority has published its interim report on its market study into legal services. It concludes that competition in legal services for individual and small business customers is not working as well as it could. The CMA has found that while there have been some positive developments, upfront information on price and quality is often not available to the customers. On the issue of regulation, the CMA is open to the possibility of moving to a new regulatory model, but recognises the risks associated with such a change. Comments on the interim report can be submitted until the 19th of August. The Ministry of Justice has also launched a consultation on proposals to amend the Legal Services Act 2007. This follows a report that the government published on the 30th of November 2015, when the government pledged that it would consult on removing the barriers to entry for alternative business models in legal services. Thank you for joining us for this month's Commercial Bulletin. The website details of Radius Law and LexisNexis will be shown on your screen in a moment. Please feel free to contact me if you'd like more information on any of the topics covered. And if you've not already done so, you can get access to more content with Lexis PSL. Please don't hesitate to contact my colleagues at LexisNexis to request a free trial. Any other feedback on our bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.